All right, so we do have a few more people that are going to be coming on, but I think that in the interest of time, we should get started. So hello and welcome to making sure you have the right tools in your toolbox for protecting your elders, a Ruth's House Lunch and Learn exclusive. I hope everyone is doing well and gearing up for winter. I know, yep, I said it, sorry, but it is going to be like 12 degrees tonight if you've seen the weather, so just saying.
No smirking, Laura.
Just saying.
We appreciate you being here and hope you have some great takeaways from the presentation. I want to thank you in advance for your patience in case we experience any technical difficulties as we navigate through our virtual platform. This presentation will cover some of the key points you should be aware of while caring for your elderly loved ones. This presentation will be interactive and there will be time for Q&A at the end. To ask a question, either raise your hand or type in the chat section. We will try to get to as many of your questions as possible. Once I'm finished, my co-host Christina Tui will give you a quick virtual tour of our beautiful assisted living residence, Ruth's House. Of course, normally this is where the Lunch and Learn is held in person. Christina will introduce Michelle. Michelle will present. We will have a Q&A segment. And I know that as we continue through, flu season now starting on top of COVID, there's an even bigger concern out there for all healthcare facilities. How are we keeping your loved ones safe? And while I can't speak to everyone else, I will be able to show you a short 3-minute video to let you see our efforts. While of course I picked the raffle winner. We have a $25 gift card. So the next Lunch and Learn will be on us. So some of you already know me. My name is Marianne Shelb, and I'm the Director of Business Development here at JGS. The JGS campus is not only a great place to work, but also to live or rehabilitate. With that said, I would be remiss if I did not take this opportunity to give you a quick campus overview, since I hear all too often that folks do not realize what we have to offer here. So I have to go back to sharing, so give me a second. Over here. 2 screens is great until you're trying to share and it's like, all right, which one? All right, we're gonna go to 1. Share screen. And then let me see. Current slide. All right, so hold on. It's not actually, give me 1 second. This is the technical difficulties that I said to thanking you for your patience in advance, right? Okay. Try this one more time. Share 1. Hang on. Thank you for being patient. Okay, here we have our JGS campus, 23 acres. I don't know if everybody realizes how many acres we have here right in Long Meadow. This is actually showing the whole campus with all of the entities. We have the Levitt Family Jewish Home, our 24-hour skilled nursing. Oh, we've got somebody else, let's admit, sorry. Our 24-hour skilled nursing home, including long-term care, rehabilitation, and memory care neighborhoods. We've got the Sossin Center for Rehabilitation, the first greenhouse model of care in Western Mass, featuring 2 small houses, all private rooms, all private bathrooms, consistent care teams, all in a home-like setting. And if you're looking at the photo, this is literally, this could be any one of our homes, right? You've got the kitchen table, and then you've got the dining room table, and then the kitchen behind you. Very, very home-like. If you haven't seen it, I recommend after we can actually have tours come in to come by and look at it in person. We've got the Wernick Adult Day Health Program, your loved ones safe and cared for in a dynamic setting, promoting social interaction and stimulation while you are able to work or run errands without worry. Hold on, another one. Spectrum Home Health and Hospice, quality care that comes to you in your own home with a personalized plan for each patient since everybody is different. Genesis House, senior independent living with efficiency in one-bedroom apartments located on the JGS Life Care campus with access to our family of services for your continuum of care. Last but not least, of course, Ruth's House Assisted Living residents. Set back away from the main street, nestled amongst the privacy of a wooded backdrop, lies our gorgeous home-like setting for both traditional and memory care residents. Now, with that said, Christina is the pro for Ruth's House. I will stop share. And Christina, all you.
Thank you. So I'm going to share a video that I pre-recorded so I don't have to forget anything. So I hope you enjoy it.
Surrounded by lovely landscape grounds and private walkways, Ruth's House Assisted Living in Longmeadow, Mass. Is part of the 23-acre comprehensive campus of care at JGS Life Care, guided by Jewish values, serving all faiths. Ruth's House is a beautiful home-like residence for seniors of all faiths who value their independence but may need assistance with day-to-day living activities. If your loved one is transitioning to a new lifestyle or needs extra care they can't receive where they live now, we'll make them feel right at home. Ruth's House offers 64 spacious, newly renovated apartments that residents can decorate and personalize. Residents can enjoy private or companion suites. Our residents enjoy 3 kosher meals daily, kosher snacks available throughout the day, and our country kitchen. Ruth's House features inviting dining and social areas inside and out. Other amenities include linen and laundry services and transportation to events and outings. All of this comes together to create a warm and inviting atmosphere that helps promote a strong sense of community for both residents and staff. Residents appreciate social and cultural events, including day trips to area restaurants, events, and attractions. Our memory care outings are specially designed for the enjoyment of our memory care residents. We also offer multi-denominational religious programming and spiritual support, including a rabbi on site. We believe independence is important and our residents remain in charge of their own schedules. However, they can rest assured knowing our highly trained team is available 24 hours a day, 7 days a week to provide individualized care and assistance if needed. On-site nurses provide wellness programs and medication reminders. Primary care physician services are available on site, and a licensed nutritionist is available to discuss your dietary needs. The Garden neighborhood is a memory care secure neighborhood that has been designed to support the needs and perhaps more importantly the successes of each resident with early to mid-stage memory impairments and other dementia-related diseases. Our staff has come to know each of our residents on a very personal level and strives to accentuate skills and strengths that residents retain and not focus on losses. Daily activities are designed to create experience of success and reduce anxiety in a safe and secure environment. Assisted living at Ruth's House gives your loved one the care and support they need while allowing them to lead full and independent lives. We are committed to preventing the spread of COVID-19 infection and providing our residents, staff, and visitors with a safe and clean environment. We strictly adhere to the standards set by the state and federal government, as well as the CDC and the Mass Department of Public Health.
Perfect. So thank you for watching that video. I hope it was informative. And if you have any questions, feel free to reach out. I know Marianne will leave my info at the end of this program. But now I have the pleasure of introducing attorney Michelle Feinstein, who concentrates her practice in the areas of estate planning and administration, elder law, probate litigation, health law, corporate and business planning. She has been a board member of JGS since 2016. So first, I'd just like to say thank you for your commitment to JGS and all that you do for us. She is a lifetime born and still living in Longmeadow, Mass. And one thing we share in common is we both have adopted Dixie dogs, her little dog, Missy. So welcome, Michelle. Thank you.
Thank you. Good afternoon, everybody. And hopefully Missy will not make a cameo, but you never know. Um, and she'll have to show off and trade on her cute if she does. It's nice to see some new faces and some old faces and an old high school classmate that I haven't seen in, I don't know, 40 years. So welcome, everybody. Thank you for coming. Just to let you know, your email addresses when you registered, you'll be sent, there were some materials that I prepared that you'll get like parting gifts. So there's an explanation of the documents I'm talking about. And are you doing the PowerPoint too, Marianne? Can you hear me?
Yeah, is it not showing? I have it up.
Yeah, I'm just saying in terms of email.
Oh, no, I was actually just gonna do the handout. I wasn't going to
Okay.
forward the actual PowerPoint. I mean, I
Okay,
could
that's
yeah.
that's no big deal. That's
Okay.
fine.
Okay,
So the information that's in the slides is in the handout that I'm giving. It's just in a different format. The only thing that isn't is perhaps the last slide, which we could maybe leave up a little bit longer, so that has some resources that people might want to access. So when Susan and Marianne called and said, would you do this talk? They said, what do people need? What should they have? What should everyone have? And what do elders need? So we came up with this idea of what's in the toolbox. So if you're going to plan, first of all, why bother planning? So if you don't have a plan, no worries. The Commonwealth of Massachusetts, who does everything so incredibly well, has one for you. It's called guardianship and conservatorship during your lifetime, and it's called intestacy at death. And if you don't like that plan, then you have to affirmatively opt out and do something. So, what are the benefits, perhaps, of planning besides not having the Commonwealth be your planner? So, it allows you to take care of your loved ones. It allows you self determination. You'd be amazed at who might step forward or crawl out from any particular rock and say, "Oh, I'll take care of Michelle." And it might be the one person that I would least want to have take care of my affairs. But when you don't have a plan and someone has to go to court and the judge is sitting there with their robes saying, "Well, they look okay. All right." They wouldn't necessarily know. Um, it also minimizes court intervention and minimizes legal fees and costs, which I know pains me to say because as a lawyer, mama's got to eat. But the planning allows you pay a little bit up front to do the planning and hopefully avoid a lot of cost later, whether it be court costs, taxes, any number of reasons why you might want to do that. So, what are the basic tools? During lifetime, the tools are a durable power of attorney, a healthcare proxy, a living will that's consistent with your wishes, a most order, maybe, and maybe a trust. At death, the basic tools are a will and maybe a trust. And when I say trust, we're going to talk about it a little bit later, but there's many trusts. You go into a library and say, I'd like a book. They might say, well, would you like mystery, science fiction, autobiography? Well, trust me, there's probably as many different genres of trusts as well. So just saying I want a trust without saying what you're trying to accomplish by the trust won't get you very far. Okay, so let's talk about the beginnings of the tools. During lifetime, one of the basic tools is a durable power of attorney. Quite frankly, this is a tool that it's not just for elders, it should be for anyone. A lot of folks who are married sort of have a built-in power of attorney on things like joint checking accounts. Um, I don't know how many of you would fess up to it. We're not taking names, we're not reporting anybody, but I don't know how many of you perhaps sign your spouse's names to the back of checks or sign things such that the bank wouldn't even know what your spouse's signature looks like, because you're usually signing for them. That happens a lot. But the fact of the matter is there's some things you just can't sign in behalf of your spouse. And for example, if it's important to sign a deed for making a transfer, sometimes for Medicaid planning, that's very critical. Um, if it's signing a tax return, things that are signed under the pains and penalties of perjury, probably not a good idea to practice your penmanship on your spouse's signature. So it's really a good idea to have it. And then you also should always think for any of the documents we're going to talk about having an alternate. So, very frequently spouses travel together. And if you're in a car accident, your spouse is killed and you're disabled, who do you want to make sure pays the bills? So you want to make sure that that's covered. And for people who are single, it's even more important because they don't have the initial backup of the spouse. So if you're single and you've got everything in your name alone, who's going to take care of business? If everything's in your name alone, unless you have a power of attorney, people are going to court. So, of course, there's not just one kind because, we like variety. So, the two basic initial cuts are it can either be immediately effective or it can spring into action. Think of it as an on switch upon a defined set of circumstances. It can be broad or it can be narrow. So, for example, back before there was fire and I started practicing law, when you'd have a house closing, everybody would come to the closing. The brokers, the buyers, the sellers, the lawyers, there'd be like 10 people in the room. And even pre-COVID, nobody goes to closings anymore. The sellers go to their lawyer's office ahead of time. They sign everything that they can. They give their attorney a power of attorney. The seller's attorney goes to the buyer's attorney, who's already met with their clients, and the two of them usually meet at the registry or at somebody's office and swap papers and then leave. It's a very different closing than the closing of 1984. But that's a limited power of attorney. You usually give your lawyer a power to sign any document relating to the closing to effectuate the closing. That's not the power of attorney we're talking about here. We're talking about a broad one, usually to sign anything that you could sign. Because if you're disabled, you don't want them to only be able to do one thing. You want them to be able to take care of whether it's signing your tax return or changing a beneficiary designation or making a gift or settling a bill or handling a litigation matter for you. Whatever it is you could do legally, you would want that person to do. And if there are some of those things you don't want them to be able to do, then that can be dealt with. It can be customized. So if you don't want them making gifts, or if you don't want them using your annual exclusion gift, or if you don't want them to change a beneficiary designation, you can certainly state that. Now, a power of attorney is different than a durable power of attorney. A power of attorney is something from Old English law with principal and agency law, and the agent was only as good as the principal. So if the principal, the person whose power of attorney it is, was mentally disabled or physically disabled, then the agent could only be as good as the principal. Well, that's great, except for if you want to provide when the person's disabled, that's not very helpful. So there's a statute, and these durable powers of attorney have abracadabra language in it that's a creature of statute, and the statute provides that if it contains this language, this power of attorney shall not be affected by my subsequent disability. Presto, changeo, wish I had my magic wand. Poof, it's a durable power of attorney. And even if you sign it today when you're healthy, and tomorrow, God forbid, something happens, and the next day someone needs to use it, it's not affected because you became disabled. So an immediate effect is just what it sounds like. The second you put your pen down, that power of attorney is in effect. A springing one, and I typically use these for people who are younger and it's less likely to be used in any time soon. And people in the 30s and 40s or younger, I'll do a springing effect that says this shall only come into effect if designated by my attending physician that I'm disabled, if they certify it. But as people get older, in their 70s, their 80s, their 90s, the likelihood of using it becomes much more frequent because they are less likely to be interested in dealing with it. They may want to still be able to do things and not be certified as disabled, but they might just need a little help. And I don't know about you, but if you've tried to call the bank or an insurance company or even someone on a medical bill, unless you have a durable power of attorney that's effective, then they're not talking to you with all the privacy laws. So it's typically better to do it immediately. And then, it's only if it's really not that likely it's going to be used anytime soon to do the springing, because getting the certification and then, if it's 6 months old, they'd say, well, maybe they recovered. I need a new physician certificate. It can become very cumbersome. Just because you have power of attorney doesn't mean, woohoo, keys to the kingdom. Go back one slide. You are a fiduciary. And as a fiduciary, you have obligations to act in the best interest of the principal. Okay, next slide. So what's another sort of basic tool of that you'd want in your toolbox? A healthcare proxy. So they also are a creature of statute. And the healthcare proxy in Massachusetts is basically, we never adopted a living will statute. California, for example, has had a living will statute for decades. Massachusetts still doesn't have it. But what we do have is effectively a durable power of attorney for healthcare. It says if there comes a time when I cannot make or appreciate healthcare decisions and I can't communicate them, as certified by my attending physician. So by the effect of what it is, it's a springing power. It only springs, you sign it today, but it only springs into effect when the doctor documents in your chart that you are incapable of making or communicating healthcare decisions. It then springs into action and you are recognized as the healthcare agent to make medical decisions. It's not a living will. However, you can incorporate the kinds of wishes with respect to that. Massachusetts has long been loath to adopt the living will, and I don't think we ever will. But what you get is substituted judgment. So if it ever went to court, the court's going to say, well, what would Michelle want if she could sit up in bed and tell me? So, if you have a signed, written, witnessed, notarized statement from Michelle that says, if there comes a time when I'm in imminent risk of death, terminal illness, no likelihood of recovery, coma, and the other list of horribles, then in such events, do not take the following steps. And it lists them: mechanical ventilation, artificial nutrition or hydration, mechanical resuscitation. That's pretty compelling evidence to a court. And unless they have evidence that says, oh no, she revoked it, that's going to be compelling. There's also statements like 5 wishes, et cetera, that are, tools that will help provide a substituted judgment. So they're always worth doing because it's evidence of what your intent is, whether you do want those interventions or not. If you do want to stay at home if possible versus being in an institutional setting. And it also, our particular healthcare proxy also gives releases to get information under HIPAA, because Lord knows HIPAA is everywhere. I've gone to a bank and they say, oh no, we can't release that information because of HIPAA. HIPAA has nothing to do with bank records, but everyone's conditioned, it's HIPAA, we can't do it. So they've gotten the message that you have to be very careful with HIPAA, but it's a little misplaced. But nevertheless, there is a statutory form that's just basically I name A, and if A is not available, then B. We recommend that you put on people's cell phone numbers if possible, because not everyone's home, and cell phones tend to be a good contact, and people tend to keep their cell phone numbers even if they move. We also, if you want us to draft it or have your lawyer draft it, they tend to be much more comprehensive and encapsulate some of your wishes more than the basic statutory form that if you have nothing, you check into the hospital for an elective procedure, they'll say, do you have an advance directive? And if you don't have one, they'll give you one to fill out on the spot. Next slide. So there's something else called a MOLST order, which is an order regarding a medical order regarding life-sustaining treatment. That's different than a healthcare proxy. This is a document that's created with the individual and their doctor, and it's a medical order. It's not a substituted judgment. It's not what should we do or not do in this particular situation. It is a medical order that's created in advance after a discussion with the doctor, and it's actually a medical order already in place. So whereas a healthcare proxy would consent to treatment or consent to an order, this is already an order that's consented to by the individual. So it's not like you should just have one now when you're perfectly healthy and everything's fine, because you don't necessarily know what might be appropriate. But, if you get, a significant diagnosis and there's a progression to it and you have definite feelings about what you do or don't want, that is a useful tool to sit down with your doctor and create a MOLST order that gets put into your medical record. Some people actually put them on their refrigerator, which I think is just really depressing to look at that every day. That's one way to lose weight, I guess. But it's certainly something that I would find a little sobering. But it is something that, for example, if someone's in end-stage kidney disease and they don't want dialysis, that would be a conversation to have with your physician and to make sure that that's documented. It isn't just pull the plug. It can encompass a lot of other things. Next slide. So adult protective services is another thing to be aware of. Elder abuse is defined as the mistreatment or neglect of a person 60 years of age or older. I was really depressed to find out that I'm in this category. By an individual known to them, including physical and emotional abuse, caregiver neglect, financial exploitation, and sexual abuse. You'd be amazed at how much of it there is. It's it's really much more rampant than we give credit for. And it's unfortunate. And a lot of it isn't documented or reported, but it's there. And a number of you in the room are what we call mandated reporters. And if you see it, you have to say something. But at the same time, next slide. At the same time, if you have the starting point is the elder competent? That dictates the course of the investigation. An elder has the right to refuse investigation or intervention. They have the right to determine who is investigated and may give the investigator information. They can withhold consent if they say to the bank, do not give them the information, or to the lawyer or the accountant, do not give the information, and they're competent, they don't have to give the information. If the protective services is concerned, they can go to court to get an order to do the investigation if they feel that the person is being unduly influenced or incapable of giving consent. But unfortunately, just as there are many battered spouses who are competent and stay for the battering, unfortunately, we believe in self-determination and independence. And if the person is competent, they can, in fact, say, I'm okay with this, even if it's a terrible situation. So competence is the first cut on this. I did have a client years ago who was competent and I feared was being abused by her child. And we were trying to get her out of the situation. And ultimately, she decided not to do it. She came in with a broken arm, but she was competent and it broke my heart. But I was prohibited by the canons of ethics. I actually got an ethic opinion about it. If I could break that to take further action, and I could not because she was competent. But what happens if the elder is incompetent? Next slide. If the elder is incapacitated, then an order of the court can be sought under Mass General Laws 19A, Section 20A if it's not an emergency, or 20B if it is an emergency. It's for the provision of one or more protective services for the elder. They have to be suffering from a reportable condition and lack the capacity to consent to protective services, or they require a determination of their capacity to status to see whether or not they're capable of giving a consent. So if you're not sure if they are able to give consent or not of being competent, you can go into court to get an order to determine capacity. And if they're determined capable, then it might end your inquiry very quickly. But if it comes back as not capable, then the next thing would be to launch an investigation if there are allegations of neglect or abuse as we defined in the earlier slide. So what can protective services do? They can access to the elder is limited by anyone other than the alleged abuser. So if there's isolating of the elder, nobody can get into the house, nobody can talk to them on the phone, everything is being intercepted, where they need to determine their capacity, or they are afraid that money's going out the door, they can seek an evaluation, the freezing of assets, suspension of the power of attorney, because that person might be the abuser, and they can enjoy any interference that they're receiving. So reportable conditions are physical harm, financial exploitation, threats, or emotional abuse. And it's unfortunate, but as many of you are out there on the front lines with elders, whether you're a care provider or a care manager or someone who's seeing elders regularly in your practice, or if you have family members and you see this stuff, if you're a layperson, you're not a mandated reporter, but you certainly can report it. And if you are working in this field, you are likely a mandated reporter and you have an obligation under your license to report it. So you report it to protective services, and there is information on that under Executive Office of Elder Affairs. They have a hotline 24/7 that you can call. Okay, so let's get out of icky stuff. And what are some of the other tools? One is trust. I kind of think if the others are basic tools, trust is more like a power drill. It's a power tool. What is a trust? It's an agreement between a grantor, who is also known as a donor, settlor, or creator, because if one name is good, three are better, and a trustee, who's also kind of like a manager. So the trustee manages the property that is placed in trust for the benefit of the beneficiaries who are named in the trust. The trustee is held to the highest duty of care imposed by the law. It's a fiduciary duty to manage the trust property prudently and in the best interest of the beneficiaries, not in the best interest of the trustee. Even if the trustee is one of the beneficiaries, the trustee has to look at everyone and see what is best for everyone. So how does it work? The grantor sets up the rules. Can you go to the next slide? Thank you. The grantor sets up the rules. The grantor's in charge. They can impose conditions, distributions, define the level of discretion, and they can give beneficiaries no rights, some rights, or expansive rights, whether it's demanding distributions, removing a trustee, or participating in investments. So, for example, you can have a trust in which you're the grantor and you're the trustee and you're the initial beneficiary. But upon your death, it's going to go somewhere else, whether it's to children, other family members, favorite charities like JGS, or whether it's any other cause that you find appropriate. So it can act as a will substitute. But more importantly, during your lifetime, it can act as a basket that holds all your assets and is managed in one pool. So if I have a bank account at TD Bank, and I have a brokerage account at UBS, and I have a piece of property, and I have whatever else I have, if they're all in the name of the trust, then the trustee can control all of them because they are all in the basket of the trust. And the trust can invest, if they don't like the investments at UBS, they can go to Morgan Stanley, or they can go to, wherever they want to go. They have the ability to open accounts, close accounts, etc. They can also impose conditions. Well, it's okay to make gifts, but only to this class of people. Or I want you to make the annual charitable gifts that I always make. Or I want you to provide for my family, even while I'm alive, I want you to provide for additional funds, as I always have when I was healthy, to my spouse and to my children and grandchildren. Or I want you to focus on paying for their education or contributing to a 529 plan. It can be very specific. It also can say that the trustee has unfettered discretion, which is not complete arbitrary and capricious discretion, but it can also say, in their discretion, acting in for their health, education, maintenance, and support. It can say having due regard for other assets. It can say pay for absolutely every expense in these categories. It can say pay for education only. I've had people who have provided for loved ones and saying, look, I want them to work. I don't want them to be trust fund babies, but I want this to be for their retirement. So it said, unless it's catastrophic, then it's only for their retirement and they can only access it when they attain age, whatever. So it can be very specific, or it can be very, very broad. And the beneficiaries might have the right to accountings. They may, if they can't handle an accounting, a trust protector may be appointed to review in their behalf. They may have the right to hire and fire trustees, or maybe someone else has that right. And sometimes they're allowed to participate in the investments, but not in the discretionary distribution decision making. So it can be pretty broad, or it can be very narrow. So, like I said, there's a lot of trusts. There's living trusts, there's irrevocable trusts, there's all kinds of trusts. But let's just start with the one that's lifetime here that we're talking about, living trust. It can be revocable. The grantor, creator, settlor, whatever we're calling them, they have the right to alter, amend, or revoke it at any time. And I add a little asterisk because if you're incapacitated or at death, it becomes frozen in time and irrevocable. They can take in assets, they can take out assets, they can direct property in it through their will. Their will can say, I leave everything to my trust. They can fund everything that they can think of during lifetime in their trust, but sometimes there's a last paycheck or the winning lottery ticket. That would be my luck. I would get the winning lottery ticket and not get to enjoy it. But, whatever might be in your hands when the music stops can be poured, they call it pouring it into the trust with a bequest in your will. or it could be irrevocable right from the get-go. And sometimes people do that for tax purposes to make gifts into a trust and have them count as intent, delivery, and acceptance of a completed gift. If they are irrevocable, then it's sort of what it sounds like. They can't be altered or changed once signed. There's a little asterisk. There is a way to do it sometimes. It's not always possible, so you can't depend on it, depending on what type of change you want to make. So you should start out with the idea that if you're doing an irrevocable trust, it's set in stone. But there are reasons when you can change them in different ways. You can either go to court if there's been a major change that was unforeseen, like in the law, that would make the trust not workable, or there can be reasons to do it. But in general, you should think of irrevocable as just what it sounds like. Okay, so next slide. During lifetime, the thing that makes trust helpful is it provides for continuity of management. If it's my trust and I've established it, and I'm the trustee, and everything I own is already in it, and I become incapacitated, then the next trustee steps up, certifies that, gets a certification from a doctor that I'm incapacitated, or maybe they're their co-trustee already. They just pick right up, everything's already in the trust, and they can write checks. They don't have to run around to the bank or get signature cards or whatever it is they have to do to get them to accept it. It's already there. They don't have to move anything. At the grantor's death, anything that's already in the trust can avoid probate, which is especially useful when people have property in other states. So if you have a condo in Florida and you have property here, if I own both of those things in my name alone, I could be looking at a probate in 2 states. If, however, I've put both of those things into a trust, I don't have to go to probate for either one. Don't get me wrong, you still have to deal with the tax man and file estate tax returns to clear liens, but I don't have to go through the probate process. Ownership is clear, it's in the trust already, and the trust says what the rules of the game are of who gets what and when. So it makes it much easier to administer. It doesn't get you out of taxes per se, but it does in fact make it quicker. It also can say, let's say you've got what we call the yuppie estate plan, got people in their 30s and 40s and they've got young kids. If you do nothing, the Commonwealth of Massachusetts says, great, when when those kids inherit, they're 18. And 18-year-olds and 30-year-olds usually have very different interpretations of what they need and what's appropriate to spend things on. So if you want to delay what we call vesting, when they can actually take the funds out without supervision, it'll always be available to them if that's what you want, as drafted in the trustee's discretion, to pay for school, to pay for insurance, to pay for the school trip or whatever it is. But it's a difference between asking the trustee for money. Dear Mr. Trustee or Ms. Trustee, could I have money? I want to take a year abroad and I'm studying this, that, and the other thing, or I'm starting a business, or I'm going to go to college and I need money, versus Dave Matthews is touring in Europe this summer and I want $50,000 because me and my friends are going to, saddle up and go. If the trust just says it's payable at 18, the trustee has to hand them the money. But if it's in trust with discretion, the trustee could say, well, if you want to take the summer off, you've worked really hard. Okay, whatever you earn, I'll match, or I'll give you some, but there's discretion. There's an ability to delay that. And, and there's always the fear of they take everything out and go to MGM and put it on red. So you don't want to lose it all in one shot. It can control the distribution to beneficiaries. It also is especially critical if there's any family member, whether it's an elder or a child, who has special needs and might be receiving public benefits. If they receive a bequest outright, they can be disqualified from getting those benefits. And the only way to keep their qualification is to do what they call a self-settled special needs trust, which means it's their money, they're entitled to it legally, and they'd be thrown off but for putting it in this trust. They put it in the trust and they can use it during their lifetime, and whatever's left, they have to repay any benefits they've gotten. If the parent who was leaving them a bequest or the grandparent instead had left it to what they call a third party special needs trust, so it's my trust and I'm leaving it for my niece or nephew, then I'm putting money into this trust. It's for their benefit during their lifetime, and there's no payback provision required. It can go wherever I say upon their death. They also can be used for tax planning. Massachusetts has an exemption of $1 million, and anything over and above that can be estate taxed. And anything you give to your spouse is tax-free. So we can put assets in trust. The first $1 million is available to the spouse, and they can even be the trustee of it with certain guidelines. But it's not going to be counted when the second spouse dies in their estate if it's drafted properly. The other thing that really is helpful about trusts is we're a complicated society. It's not just Ozzie and Harriet anymore. We have blended families, yours, mine, and our children. We have multiple relationships, not all of them successful. So rather than everyone competing in the same pool of money, a trust allows you to segregate assets and give different pools to different people so that they're not, in fact, fighting over assets. And you don't want fights. Fights are bad. But I would say we get contacted. Back when I started, it'd be maybe once every few months with a potential will or trust contest. We get several a week now. And the typical pattern is where there's not a traditional family. I would say probably 1 out of 3 or 4 is a traditional family, and the rest are blended families where this comes up. So it's not like it never happens in a regular family or the traditional family, I should say, but by far it is more when there's competing interests among family members. So, as I said, when you ask for a trust, there's all different kinds. So I'm just giving you a list. I could do multiple slides on every one of these, and there's still way more that I haven't listed. But just to give you an idea, there's a marital deduction trust that takes advantage of that $1 million, or for federal purposes, 11,580,000. So if you guys are over that 11,580,000, and with portability, you and your spouse can combine, that's 22, almost 23 million. For those of us in that atmosphere, you probably already have these things. But for us, the rest of us mere mortals who are, more in the Massachusetts range, it's $1 million, and we don't have what is called portability, meaning you and your spouse can combine your exemptions if the first spouse doesn't use it. You actually have to line your assets up correctly. We've talked about special needs trusts. Irrevocable life insurance trusts are another popular one, where a trust you create as irrevocable now holds life insurance. And then upon your death, it's paid to that trust. And it's a pool of money that's outside of your taxable estate. So, if I own insurance on my life right now and it's payable to my spouse, that insurance policy, the whole face value of it, is included in my estate when I die. So if it's $1 million policy, I've got a taxable estate already. But if I had it owned by that trust from the get-go, then that $1 million wouldn't be payable, be includable in my estate, nor my spouse's. So it's a way to provide a pool of money to pay taxes, to pay for liquidity without adding to the tax burden. Charitable remainder trusts, one near and dear to our organization. You can provide for your family up front, and anything that's left in it when you die goes to the charity or charities that you designate. And there are particular rules of how to do that, so you get a tax deduction for it on your estate or your income taxes, but it's certainly a tool. Qualified personal residence trusts are another creation of taxes where you freeze the value of a home or a vacation home, and then can make provisions if you want to keep the Cape House in the family. It's a way to do it at a minimal tax cost. Income only trusts tend to be a tool that we use in Medicaid planning, where people transfer their assets to an irrevocable trust. There's a 5-year disqualification period under the Medicaid rules. And if all the elder has is access to income, but not principal, then the principal thereafter the 5 years is preserved. And if the elder can't get at it, neither can Medicaid. So that's one thing that people do with the house. They sometimes put that in income only trust. If the house is sold during lifetime, the elder is entitled to the life estate value, but the principal remains protected. And grantor retained either annuity trusts or charitable remainder annuity trusts are, my dog just came and jumped on my leg, sorry. The grantor retained annuity trusts are vehicles where the grantor puts principal into a trust and receives an annuity for a period of time. And then whatever remains at the end, they usually are created to zero out, meaning if it's $1 million, you get 500 in the first year, 500 in the second year. and it's payable with interest at the lowest applicable federal rate, which is very low right now. I'm trying to remember. I actually don't remember what it is, but it is an incredibly easy threshold to beat in the investments. So let's say the AFR was 0.05%, and you have a return on your investments in the trust of 15%, then because the market's been crazy, so you pay out the 500,000 plus that 0.5% of interest, and then the second year you pay out the second 500 with 0.5%, and that 15% that it earned each year that's still in the trust can be distributed either to beneficiaries if it's a grant or retained trust, or to the charity. Next slide. Next slide. Okay, charitable trusts, the grantor retains an annuity, for example, payable during their lifetime. Whatever is left is paid to the charity. They can, this is a great tool for appreciated property where you don't want to pay capital gains and then make a contribution. And it can be payable for life or for a term up to 20 years. At the death of the grantor, the charity receives the balance. The grantor gets an upfront charitable deduction on their income tax, and they also get an annual income, which is based on different tables than the life estate tables that are used for calculating the lowest applicable federal rate. So they tend to be much higher than what you're getting paid on commercial annuities. And that makes them an attractive vehicle for something, for money that, let's say there's money in a savings account that the grantor really always thought was going to go to charity, and they want to give it to them, but they could use some income. It's a great vehicle. Maybe they're going to get 4 or 5% on the charitable annuity during their lifetime. And at death, whatever's left in the account is going to go to the charity. Okay. So that was all great, but now it's a question of how do we put all of this together? So I came up with a little hypo that I thought would be helpful, that would illustrate some of the points. So Edward is a widower, and he's physically disabled and has been living in a senior apartment independently. He has 3 children, Jack and Jill, who live nearby, and Michael, who lives in Texas. Jack has been helping Edward and is his healthcare proxy. Jack is worn out and wants to quit. In fact, those are the very words he uses. And he's getting calls from Edward frequently, and he's just burnt out. And Jill and Michael and Jack all have different ideas of what they think is in Edward's best interest. Edward has some resources. He's still competent, though he's slipping. There have been a few fender benders, a little forgetfulness, and he had a scare with COVID recently. Jack wants out. He wants a break. What can be done? And this is a situation that comes up frequently in families. And one of the first things that comes up is, what does Ed really need? What should he stay in independent living? Should he move to assisted living? Does he need a nursing home? From these facts, it doesn't sound like he needs a nursing home, but he may be someone who benefits from assisted living. But, you might have Michael, who lives far away, saying, well, I think he's perfectly fine. He wants to stay there, and he's not boots on the ground. He doesn't know. And Jack and Jill can't decide. They can't agree that the sky is blue on Tuesday. So how do you figure this out? One of the things that can be very helpful is getting a geriatric care manager, because if everybody lawyers up, which has happened, and you spend a ton of dough on lawyers, which, don't get me wrong, I'm all for it. It's great, but it's not my preferred mode. I think it's better to spend the money on the elder and have it, if everyone can agree to let a professional make a determination and evaluation of what's needed, then you can spend the money on the care and not on the lawyers and court. I mean, I actually had a 3-day trial on a guardianship of an elder where the sister and brother couldn't even be in the same room ever. And they both wanted what was best for mom and dad, but they had wildly divergent ideas of what that might be. And we tried to mediate it. We tried to get an independent professional to decide, and there was no go. And it was 3 days of trial and lots of money that could have been paid for their care. So some of the things that you can think about, if they have resources, maybe they can afford assisted living. Maybe that's the right answer, that it provides a pool of services that can really be helpful to the elder and socialization. Maybe they don't want to leave where they're living. They are very happy there. Maybe they need services brought in. Well, a geriatric care manager or a nurse manager can help, wiggle through the red tape of what it takes to get the right people in there to make sure that there's the appropriate level of coverage. Maybe they, make arrangements because Papa Bear is messing up on their meds, and maybe they make arrangements. There's different places that do the bubble prescriptions where, it's a takeoff, I guess, of the pill box. But these are the ones you take now, and if the bubble is empty, then you took them. It can be any number of suggestions and interventions, but it can be very helpful. Maybe it's getting them on mass health, and they can either go through private counsel or they can go with Greater Springfield Senior Services. They have options counselors that can help figure out what options are appropriate. There's programs of all-inclusive care that help find different resources. If they don't have a lot of resources, but they own a home, maybe they get a reverse mortgage. Maybe they, that lets them use their house as an equity line. There's many different possibilities to provide for the elder. But one of the first things that everyone always asks is, do they have a durable power of attorney? Do they have a healthcare proxy? Because if they're still competent, that's the first thing you want to make sure they have. Because if they lose competency or things happen, you want to be able to still provide for them and do for them. And you won't be able to unless you go to court otherwise. So I think with that, I can open it up for questions.
Yeah, let me stop sharing for a second. Hang on one second.
There's no more sharing.
We could get everybody, no more sharing.
No more
could get
sharing.
Get everybody back on for gallery view,
So we just did a very quick romp through Estate Planning 101.
which was great, which was absolutely great. I'd like to be able to open it up for questions. So I will man the chat, and then literally if you just kind of raise your hand, it looks like you all are on one screen for me. So if you want to just raise your hand, unmute yourself, make sure you unmute yourself if you have any questions. So yeah, I've got Laura. Laura, make sure you unmute yourself. Go
Hi.
ahead.
So I just have a question about the portability of the durable power of attorney and the healthcare proxy and all that from state to state. So living will.
Right.
Sorry.
So those documents, if they were validly executed in the state of origin, and now let's say the elder has lost capacity, they will still be honored. Just like a will, if you draft a will in California and you come to Massachusetts and it was properly done in California, that will be accepted. However, it might not be as efficient, and it may not contain some things that people look for here that they didn't need in California or they handled differently in California. So if it's possible to update them to the current, what's doing in the state where they are currently domiciled, that's great. But if they can't, it may be a little more cumbersome to work with, but it will be recognized.
You mentioned that Massachusetts doesn't recognize the living will. So my parents have a living will that was drafted like 8 years ago in Florida. So does
right, but
count?
it's useful and it's evidence of their intent. I still draft them for people who want them here, or I incorporate that language into a healthcare proxy. So it's never anything that's been officially recognized, but it is absolutely understood to be evidence of intent. And should push ever come to shove and you end up in court on a substituted judgment and you hand it to the judge as, look, this is the statement they did, that's very persuasive. And it was done when they were not an extremist. So I would absolutely hold on to it. It's useful, but I just want you to understand that in Massachusetts, there is no such animal officially.
Okay, thanks.
Sure.
Who else? Any other questions? I don't see anything in the chat, but just feel free to raise your hand if you want a little bit more information.
I have a question. So
Go ahead. Yep.
I might totally be misunderstanding this, but what, can you hear me okay?
You're breaking up a little bit.
I know I have a bad connection. I apologize. We'll try again. Why do we hear that there is a tool to protect your assets so that you won't have to spend it all in a skilled facility. Is that true or not?
Well, I'm going to give you the lawyer answer. It depends. So,
Hear the
there are-
term trust thrown out there all the time.
right. Well, there's different kinds of trust. The revocable trust does not work. That income only trust that I mentioned is one that does work. There's a lot of techniques. If you work with an elder law attorney, they're very familiar with them. It can be something as simple as transferring the property and reserving a life estate to putting assets into an income only trust. But you need to understand what those tools can do and what they can't do and what the drawbacks are. Because if sometimes I'll use a remainder deed, which is you transfer the property to your kids and reserve a life estate, which is great. But if your kid files bankruptcy, you need to understand the ramification of that on you and what happens. But there is no one, you do this and you're good. Every situation is different. You have to look at what the assets are, how much time frame do you have between now and going into the nursing home? If you're really looking at less than a 5-year window, no one has even though some people walk around with a crystal ball. I didn't get one in law school. Sue, did you? I don't remember getting one when we were at school. So if you don't get the crystal ball and you don't know for sure that you got 5 years, putting something into an irrevocable trust that you can't get back out can become very problematic. So you might do something that you can give it back if you have to. And that would be, something when you've got a less of a time frame. But you've got to look at what the assets are, making sure you can pay for that 5-year time period. Or if not, that you can at least get it back and understand the risks of what happens if you give something away. And even if you have the best kid in the world and they get sued or they file bankruptcy, you could have that mean old trustee in bankruptcy who won't give it back. So there's not one technique that works in every situation, but there are many arrows in an elder law attorney's quiver that they can recommend or suggest as options. And the earlier you plan, the better. It's a federal law with a 5-year look back.
It would seem if you have a blended family, which I do, you'd better be talking to an elder care attorney.
Right. And one thing that we didn't touch on yet, long-term care insurance is huge. And depending, let's say you live in Connecticut, for example, in Connecticut, they have something called the partnership. And if you get a long-term care policy that can pay out up to $600,000 of benefit, then it protects $600,000 of assets. And that there's a person that I'm dealing with right now. Their parents lived in New York. They had a policy and it came time to go into a nursing home. And instead of staying here, they were going to put the parent in a nursing home in Connecticut because Connecticut recognizes the partnership and they wouldn't have to spend them down to $2,000, which is what an applicant can have, or their spouse can have $128,000. So those are things to take care of. A lot of times we get a blended family where there's been no planning done and we end up negotiating family agreements about we're putting everything in the name of the community spouse, even though that's not what the couple had decided would happen. When they just died, it was going to be split up in a particular way, but we have to retitle it so it doesn't all get dissipated and gone. And then we have a family agreement that says we understand that everything is in this name, but we also understand that this is what's now going to happen to it so that the intent of both parties is honored. But it can get sticky.
Can I ask one more question? I don't want to monopolize here, but so in my particular case, I came into the marriage with 4 children. He came into the marriage with 2. So to me, equitably, if there was any division, it's a division of 2 to 4, and I can just see children having issues with that.
Yeah, when you have a blended family, you really want to make sure that you're looking into it. And are you splitting it in 6 or are you splitting it 50% among 4 and 50% among 2? So those are the questions that really need to be addressed.
Yeah, interesting. Thank you.
Sure.
Lisa, thank you. Before I go to any more questions, I want to make sure we did talk about the benefits of geriatric care managers. And I know, I see Jim Ferry is one here. Hi, Jim. I want anybody else who is a geriatric care manager, if you could put your information in the chat section, you guys are really helpful for us in the elder law, in the elder community, not elder law. I mean, I'm sure for Michelle also, but for us, there's sometimes when families they don't see eye to eye, and it really is important for us to be able to have a neutral person to be able to mediate and neutralize some of that negativity and the combativeness of the siblings. Sometimes it gets really uncomfortable. So Jim, and then if there's anybody else that does geriatric care management, just if you could put your information in the chat. So if there's anybody, and then put the areas that you cover. So the location, just if somebody happens to be looking, they could, maybe utilize you, look you up, call you, and maybe ask some questions, or maybe they need your services. So if you could do that, that would be great. Great. Oh, Katie. Yep. Totally. I missed you. I know I don't see everybody. Hi, Katie. So I want to see, is there any other questions? I just want to see if there's anything else that Michelle could potentially answer before we go to the next segment. It looks like we're good. Michelle, do you have any I don't see any hands raised. Let me just check the chat. I think the chat just had the information from, yeah, the geriatric care managers. Okay.
Well, I think I did a very quick romp. People are probably reeling. But
I know.
there are materials that we will email to you that will provide a quick summary. And obviously you should check with your lawyer or your professional if you have any questions.
And Michelle's contact information will be there in the emails that I send out, as well as mine. So just know that there are resources for you. So I want to, of course, Michelle, thank you so much for an incredible presentation. It was chock full of great and useful information. Some people, I think, sometimes it seems repetitive, but then there's always something you miss, or there's always something different you hear. It's like watching a really good movie over again. It's like you missed that part. So I really appreciate you taking the time. I know you have a really busy schedule. So I appreciate all the questions. That was helpful as well. I want to thank everybody for attending. Anyone who has registered, like I said, I will be forwarding the handout that Michelle has so kindly provided. I would like to now slide. All right, so give me 1 second. All right, 1 second.
And while Marianne is doing that, I did want to mention that, when we talk about geriatric care managers, there are a host of other professionals that can help with family dynamics. Sometimes it's the elder law attorney talking about, working through issues with the family and coming up with solutions. For Ed, in that situation, what I actually did, we had a geriatric care manager become the boots on the ground. The Michael, who was far away, ended up becoming the durable power of attorney, and Jill became the healthcare proxy, and Michael was the alternate. And Jack took a break, and he was available to watch, but the geriatric care manager became sort of their employee and took direction from the power of attorney and the healthcare proxy, and the siblings got to be siblings again, and they hired the help that they needed. Sometimes that's not always possible, but that was an example of how they can all fit together and work well together.
Perfect. All right, so let me just open this up. So we have a $25 gift card going to Julianne Jakes, or actually Jacques, right? If you are, oh, she's waving her hand. There she is. Congratulations. If you want, you're welcome. I'll email you, and we could try to figure out whether I mail it to you, or if you want to meet and I could buy you a coffee.
Sounds good. We'll figure it out.
Okay, perfect. Congratulations. And to everybody on the call, I want to say thank you. I'm really appreciative of everybody taking time out of their day. Christina, the Ruth's House Lunch and Learn, everybody says how great it is and how much information really we're able to give to the community. So thank you. And then Michelle, of course, thank you very much. I appreciate the time that you spent, the information. Again, every single time I hear it, I learn something new. So I really appreciate your take on it, because I took some notes. So thank you. And everybody else,
My pleasure.
I want you to have a great day. I want you to enjoy yourself. And we should actually be having another, I'm locking in, I'm hoping that it's going to be on a Medicaid presentation. And I'm hoping that Attorney Michael Hooker, and it looks like the tentative date right now is December 16th. So if you want to save that date, it's Wednesday, December 16th, also 12 noon. So it'll be at lunch. And of course, Jillian, lunch is going to be on us for next month for you. So excellent. So again, thank you everybody for taking the time. I appreciate it. Have a happy Thanksgiving. Stay safe. And until next month. Bye,
Thanks,
everybody.
everybody.
Thank you.